Hello Year 12s and welcome to this video on relevant factors when initiating a civil claim. There are 4 things that you need to do while you're watching this video. First, take the very best Cornell notes that you can. Second, use the pause and rewind functions. Use the pause function if you need to stop this video to take notes. Use the rewind function if you need to go over any information contained in this video. The third thing that you need to do is to have your vocabulary sheets open in front of you so that you can write in your vocabulary sheets the definitions of key terms or of any other words that you're unfamiliar with. And the fourth thing that you need to do is to have your summary books open in front of you. As we go through this video, I will give you some guidance as to what to include in your summary books. Once you've finished watching this video, please read the pages from the textbook referred to on this slide. And if you find any additional information from that reading that you think is useful, then make sure that you supplement your Cornell notes with that information. This slide sets out the learning intention for this video. Make sure that you write this learning intention down in your Cornell notes. As a result of watching this video and taking notes, you should be able to analyze factors to consider when initiating a civil claim. A civil claim is initiated, that is, it is started, by a plaintiff against a defendant. A plaintiff initiates a civil claim when they sue a defendant. Other phrases that also mean initiating a civil claim are the plaintiff suing a defendant, the plaintiff issuing civil proceedings, or the plaintiff bringing a civil action. These phrases all mean the same thing, but you need to be familiar with them because a SAC or exam question might use any of these phrases. As you can see, we'll be looking at 3 factors in particular that it's important for plaintiffs to consider when deciding whether to initiate a civil claim. These 3 factors are first, costs, second, limitation of actions, and third, enforcement issues. Before we look at these 3 factors in any detail, we need to understand why it's important for a plaintiff to think very carefully before initiating a civil claim against a defendant. There are at least 5 reasons for this. First, civil proceedings can cost a lot of money. In particular, the plaintiff will have to pay legal fees, that is, the costs of the lawyers who represent the plaintiff in the civil proceedings. In addition to paying their own legal fees, if the plaintiff loses, then the court might also order the plaintiff to pay the defendant's legal fees. Such an order is called an adverse costs order, and we'll be looking at this a little later on. Second, civil proceedings can be time-consuming for a plaintiff. A plaintiff has to find and instruct lawyers, attend the court hearing, and give evidence at the court hearing. Third, civil proceedings can be stressful for a plaintiff. This stress can be caused by the plaintiff having to give evidence and being cross-examined on that evidence, by the plaintiff having to find the money that is necessary to pay the plaintiff's lawyers, and by the plaintiff not being certain of the outcome of the case. Fourth, civil proceedings are public, which means that any member of the public or the media can sit in court and observe the court case. The issue that this might present for the plaintiff is that if the plaintiff's case is an unpopular one, then the plaintiff may suffer from adverse publicity. For example, it may be that a large supermarket has a contract with a small farmer under which the small farmer agrees to supply milk to the supermarket at a very low price. However, the farmer might subsequently decide not to sell milk to the supermarket unless the supermarket pays a higher price for that milk. Now, in such a case, the farmer has breached the contract that they have with the supermarket. In other words, the supermarket's rights have been infringed. However, the media might portray this as a case of a large supermarket bullying a small farmer, and that sort of publicity can be very damaging to the large supermarket. The fifth and final reason why it's important for a plaintiff to think very carefully before initiating a civil claim against a defendant is that the plaintiff might not win. It's often said that court proceedings are a lottery, and it's a very unwise lawyer who guarantees to either a plaintiff or a defendant that they will surely win their case in court. On this slide, I have set out a table that I would like you to include in your summary books. Each of the 3 factors that a plaintiff should consider before initiating a civil claim is set out down the left-hand side of this table. On the right-hand side, there is room for you to include a description of each of these 3 factors. I've included key words that you need to include in your description, and you will need to add more detail to this description as we work through each of these 3 factors in this video. The first factor that a plaintiff should consider before initiating a civil claim against a defendant is the costs of initiating that civil claim. There are 2 main types of costs. The first type of costs is legal fees. Generally speaking, there are 2 types of lawyers, that is, solicitors and barristers. A plaintiff will need to pay a solicitor to provide legal advice to the plaintiff and a barrister to represent the plaintiff in court, that is, to argue the plaintiff's case in court. Both solicitors and barristers typically charge an hourly rate for their legal services, and this hourly rate may vary from below $100 per hour to well over $1,000 per hour. A plaintiff's total legal costs will depend on factors such as the complexity of the case, the court that hears the case. Lawyers will often charge higher legal fees where the case is heard in a higher court. The size of the case, that is, the amount of evidence, the number of witnesses, the number of documents that is involved, the time it takes to prepare and argue the case in court, the experience of the lawyers. The more senior or specialized the lawyer is, the higher will be that lawyer's hourly rates, and the importance of the matter. If the matter is very significant for the plaintiff, what we call bet the house litigation, then the lawyers will generally charge higher legal fees. While Victoria Legal Aid does provide grants of legal assistance for plaintiffs in civil cases, that is, while VLA might pay for a lawyer to advise or represent a plaintiff in a civil case, the circumstances in which a VLA will do this are extremely limited. Typically, such legal aid will only be available to a plaintiff who satisfies the means test and where the plaintiff's civil case is a family law matter. VLA does not provide legal aid for other civil matters, such as breach of contract, negligence, trespass, or nuisance. The second type of costs is disbursements. Disbursements are out-of-pocket expenses. Look down the left-hand side of your vocabulary sheets, find the term disbursements, and write this definition in there. There are 3 main types of disbursements. The first type of disbursements are court fees. Court fees are payable by the plaintiff and consist of filing fees, hearing fees, and jury fees where the plaintiff has requested a jury. Look down the left-hand side of your vocabulary sheets, find the term court fees, and write this description of court fees in there. Filing fees are fees paid by a plaintiff to initiate a civil claim in a court. Filing fees increase the higher the court is, so in the magistrate's court, filing fees are between around $85 and $1,600. In the county court, filing fees are between around $300 and $1,600. And in the Supreme Court, filing fees are between around $330 and $4,800. Hearing fees are fees paid by a plaintiff for each day that the court hears the plaintiff's case. Again, the amount of hearing fees that are payable depends on the court and the length of the hearing. Hearing fees may be up to around $1,400 per day in the magistrate's court, up to around $3,600 per day in the county court, and up to around $7,700 per day in the Supreme Court. Where a plaintiff requests a jury, then the plaintiff must pay the jury fees. This is a daily fee, and this daily fee depends on the length of the hearing. For the first day, the jury fee for both the County Court and the Supreme Court is around $1,700. For days after the first day, the jury fee for both the County Court and the Supreme Court is between around $310 and $550 per day. The second type of disbursements are mediation fees. Before hearing a case, a court will often order the parties to try to resolve their dispute by mediation. Mediation fees, that is, the costs of the mediator, are generally shared between the plaintiff and the defendant. The amount of these fees will depend upon the mediator's experience and the nature of the case. Mediation fees may vary from anywhere between $2,000 to $20,000 per day. The third type of disbursements are expert witness fees. Expert witnesses are required in some cases, for example, to provide medical, financial, or economic evidence. Expert witness fees are payable by the party that called the expert witness. The amount of the expert witness fees depends on the expertise of the witness and the nature of the case. This brings us to the concept of adverse costs orders. The general rule is that, in a civil case, the court will order the losing party to pay the legal costs of the winning party. This kind of order is called an adverse costs order. Look down the left-hand side of your vocabulary sheets, find the term adverse costs order, and write this definition in there. Accordingly, if the plaintiff loses their case against the defendant, then the court will typically order the plaintiff to pay the defendant's legal costs. This doesn't mean that the plaintiff will have to pay all of the defendant's legal costs, because the costs that are payable under an adverse costs order are calculated according to a scale, and it may be that the defendant's lawyers have charged the defendant higher legal costs than the scale costs. In such a case, the plaintiff will only be liable to pay the defendant's legal costs as calculated according to the scale. Where an adverse costs order is made, a losing plaintiff will have to pay both their own legal costs and the defendant's legal costs. It is in order to save on these often quite significant costs that a plaintiff and a defendant might try to avoid the need for a court case by resolving their dispute outside the courts using dispute resolution methods such as mediation or conciliation. The advantages of resolving a dispute by mediation or conciliation are not just saving the cost of legal proceedings, but also that both parties are more likely to be satisfied with the outcome because they both have to agree with it, and, in the process, will both need to compromise. This means that there is no clear-cut winner and no clear-cut loser, which could otherwise cause a lot of bad blood between the parties. Of course, if the parties are unable to reach an agreement, then they will need to take their dispute to a court or the Victorian Civil and Administrative Tribunal for a binding decision at a final hearing. In such a case, the parties will then have to incur the cost of legal proceedings in any event. The second factor that a plaintiff should consider before initiating a civil claim against a defendant is any limitation period that applies to the plaintiff's claim. Parliament has passed laws which specify the time within which a plaintiff may initiate a civil claim against a defendant. In Victoria, this law is called the Limitation of Actions Act 1958. If a plaintiff brings a claim against a defendant after the applicable time limit has expired, then the defendant can raise a defence that the claim is out of time or time barred, and the court can prevent the plaintiff from proceeding with their claim. You're now in a position to describe the concept of limitation of actions. Limitation of actions refers to the fact that there are laws that specify the time within which a plaintiff may initiate a civil claim against a defendant, and that if a plaintiff brings a claim against the defendant after this time limit has expired, the defendant can raise a defense that the claim is out of time or time barred. Look down the left-hand side of your vocabulary sheets, find the term limitation of actions, and write that description of limitation of actions in there. Different time limits apply for different types of civil action. For example, where a plaintiff sues a defendant for breach of contract, then the plaintiff must bring their action, that is, sue the defendant, within 6 years of the breach of contract. Where a plaintiff sues a defendant for negligence for causing personal injury to the plaintiff, then the plaintiff must generally bring their action, that is, sue the defendant, within 3 years of the plaintiff suffering loss as a result of the defendant's negligence. For negligence causing any other type of loss to the plaintiff, such as financial or property loss, the time limit is 6 years. Where a plaintiff sues a defendant for defamation, then the plaintiff must bring their action, that is, sue the defendant, within 1 year of the publication of the defamatory statement. On the other hand, where the defendant has committed physical or sexual abuse against the plaintiff as a child, and the plaintiff sues the defendant for that abuse, there is no time limit within which the plaintiff can bring their action, that is, sue the defendant. There are a number of reasons for limiting the time within which a plaintiff must initiate a civil claim against a defendant. First, this provides certainty for the defendant. The defendant will not have a potential claim by the plaintiff hanging over their head for years and years. Second, the longer the plaintiff takes to bring their claim, the less reliable is the evidence likely to be, at least where that evidence is the evidence of witnesses. After a long period of time, witnesses may forget important evidence, may not be able to be located, or may have died. Finally, social cohesion requires that disputes are resolved as quickly as possible. Outstanding claims disrupt society and may cause stress to both the plaintiff and the defendant. However, a court has a discretion to extend the limitation period in a particular case if the court thinks this is appropriate. For example, as where the plaintiff has a good reason for not having sued the defendant within the applicable time limit. We now come to the third and final factor that a plaintiff should consider before initiating a civil claim against a defendant. This factor is enforcement issues. The most important factor that a plaintiff will need to consider before initiating a civil claim against a defendant is whether the defendant has the money to pay any damages that a court may award to the plaintiff if the plaintiff wins their case against the defendant. If the defendant can truly not pay the damages, then the plaintiff will have undergone the costs, time, and stress of a court case for no reason at all. In other words, where the defendant can truly not pay any damages that a court may award to the plaintiff, then there is no point in the plaintiff suing the defendant. Reasons the defendant may not be able to pay the damages ordered by a court include that the defendant just doesn't have enough money, that the defendant is already bankrupt, or that the defendant is in jail for having committed a crime and therefore is not earning any income from a job. On the other hand, it may be that even though the defendant does not have the money on hand to pay the plaintiff's damages, the defendant has income or assets that can be used to pay these damages. To get hold of this income or those assets, the plaintiff will need to apply to the court for an enforcement order. That is, an order that the defendant must pay the damages that the court has ordered the defendant to pay to the plaintiff. The word enforce means to require a party to obey a court order. Look down the left-hand side of your vocabulary sheets, find the term enforce, and write that definition in there. If a plaintiff cannot pay the damages that a court orders because the defendant does not have on hand the money to pay those damages, or if the defendant can pay the damages that a court orders but simply refuses to pay them, then there are two main types of enforcement orders that a court can make. The first type of enforcement order is a warrant of seizure and sale. This is a court order that directs the court sheriff, that is a court official, to take and sell the defendant's assets and pay the sale proceeds to the plaintiff. In such a case, the sale proceeds are applied towards the payment of the damages. If the amount of the sale proceeds exceeds the amount of damages, then that excess is paid to the defendant. The second type of enforcement order is an attachment of earnings. This is a court order that the defendant's employer must pay a percentage of the defendant's wages to the plaintiff any time the employer pays wages to the defendant. This payment continues until the plaintiff's damages have been paid in full. Look down the left-hand side of your vocabulary sheets, find the terms warrant of seizure and sale and attachment of earnings, and write those definitions in there. Of course, if the defendant does not have any money or assets and is unemployed, then these enforcement orders will not be of any use. This then brings us back to the key point, which is that if the defendant is unlikely to be able to pay any damages that are awarded to the plaintiff, then the plaintiff will need to seriously think about whether it is worthwhile suing the defendant in the first place. This also highlights the importance of the plaintiff considering whether there is another defendant in addition to the wrongdoer that the plaintiff can sue and who does have the money to pay any damages that may be awarded to the plaintiff. In particular, if the defendant committed the civil wrong, that is, infringed the plaintiff's rights, in the course of their employment, then the plaintiff should sue the defendant's employer, as the defendant's employer will have vicarious liability for the defendant's civil wrong. The good thing about suing an employer is that although an individual employee will often not have much money, an employer is likely to have lots of money, especially if it is a large company. In these circumstances, the plaintiff should sue not just the wrongdoer, but also the wrongdoer's employer, because if the employer is vicariously liable, then the court will order the employer to pay the damages that are awarded to the plaintiff as a result of the wrongdoer's infringement of the plaintiff's rights. Well, this brings us to the end of this video. As a result of watching this video and taking notes on it, you should now be able to analyze the factors that a plaintiff needs to consider when initiating a civil claim, including in particular costs, limitation of actions, and enforcement issues. You'll be practicing applying this knowledge in class through doing a number of learning activities that I will give you. In the meantime, please make sure that you read the pages from the textbook referred to on the first slide. And if you find any additional information from that reading that you think is useful, make sure you supplement your Cornell notes with that information. In addition, don't forget to complete the table that I've told you to include in your summary books. Thank you for your attention.